Hi, my name is Clement and we'll be discussing the problem question. The problem arising from the question between Abraham and Brenda is whether the painting and sculpture from the Victorian era are included in the sale of property of Brenda to Abraham are held to be features or fittings. Here the problem between the two parties are mere on the rights and ownership over the item on the surface of the land. To determine if the item is a feature or fittings, we need to look into the legal principle that distinguish both features and fittings and consider the classification of the property transactions together with the intention of both parties. We will be talking about is whether the items fall under the category of features or fittings. According to Section 205 of the Land Property Act 1925, which lays down the definition of the land, which includes tangible rights, which is anything that can be touched, which is real and personal property. It also includes intangible rights, which is rights pertaining to intangible property such as copyrights, licenses, rights to way, and easements. And all maxim solo credit, which means whatever is attached to the soil becomes part of it. Corporate heritage are defined as rights which have some real and tangible quality that includes the soil, mineral below it, and buildings and features above it. There are all aspects of property that can be detected by sense. A legal maxim which states that property holders have rights not only to the plot of land itself, but also the air above and the grounds below. Therefore, it is divided into rights over airspace, surface of land, and subterranean property. In Section 62 of the Land Property Act 1925 states that any features are passed automatically to a purchaser. Features are anything that is so attached to the land and form part of the land itself, while fittings, also known as chattels, which are removable items that do not form part of the land. In the case of Allison against Morris 1997, where it is distinct between the features and fittings. The key consideration was whether the item in question was intended to form part of the land or was merely resting on it. To determine the test for annexation, looking at the case of Holland and Hodgson 1872, where the looms which were attached to the mill either by nails or attachment to the wooden plugs which had been drilled into the floor was claimed as fixtures. Subsequently, court held the consideration on this point must be made with reference to the particular circumstance of the case, where firstly the degree of annexations to the property and the purpose of annexation. Blackburn justice regard anything that is not attached to the land will form part of the land itself. Things is affixed is a fixtures, but if say otherwise, then there is a burden of proof. He also further state that if the party have the intention to make object part of the land, then it do actually form part of the land is considered as fixtures. However, if the object is no longer affixed to the land, other than resting it on weight, it is generally to be considered as fittings, not as chattels. This case established the degree of annexation, where extent to which the object is affixed to the land, and the purpose of annexation, which looks at whether the object was annexed to increase the value of the land or whether the object was annexed for the better enjoyment of the land. The first issue from the question is whether the sculpture were made from marbles that was extremely heavy but were placed at the property to increase the overall aesthetics, considered as a features of fittings. Referring to the case of the Incourt against Gregory 1866, where the items form in the integral part of decoration and architectural design of property was held to be fixtures. In the case, court held that was required to determine if some tapestry, some ornamental statues of lion in the hall and the staircase were fixtures or chattels. Later held tapestry were fixtures as they were integral to the decoration of the rooms, where they attached as a wallpaper or frescoes. The statues of lion, the garden seats, and the vase were also features as they form part of the overall architectural design. Lord Romilly had regarded it does not depend on whether any cement is used for fixing those articles or whether they rest on their own weight, but upon this whether they are strictly and properly part of the architectural design, for the hall and staircase itself are put in there as such. Comparing to our issues of the questions, the heavy sculptures are indeed resting in on weight on the land, and as a reasonable man thinking, Brenda had placed the sculpture as a form of architectural decorations of the property and should be considered as a features. It was served as a decoration that increased the value of the land, and as it is a very rare and high value item. Similarly, in the case of Norton against Dashwood 1896, tapestry were held to be fixtures because they could not be removed without damaging the brickwork and tearing the fabric and leaving the room mean and disfigured. On the facts, state that the sculptures were made from marbles and were extremely heavy. From this, we can assume that the sculpture were to be fixtures unless it can be removed without damaging the items. Moreover, in the case of Allison against Morris 1997, where in the case Allison argued that the bungalow was separate from the land since it rested it on weight on concrete pillars and was not physically attached to the land. Court held considering both the degree of annexation and the object of annexations, the bungalow formed part of the realty. Lord stated that an object which is constructed in such a way so as to be removable may well remain a chattel, but a house which is constructed in such a way that it cannot be removed at all, save by destructions, cannot have been intended to remain as a chattel. It must have been intended to be form part of the realty. Second issue is whether the painting will hang on the wall that could be easily removed, considered as a feature of fittings. Looking at the authority of Holland and Hosson, looking at the degree of annexation, the true rule is that the object not otherwise attached to the land than by their own weight are not to be considered part of the land, unless the circumstances are such as to show that they were intended to be part of the land. In the facts of the question, the painting that are high in value were mere hung on the wall that is not really affixed to the land, but it is safe to say that Brenda had placed the painting to increase the value of the land. Citing the case of Riwali, a portrait and a tapestry were held to be fixtures because of the way they were intended to become part of how the room was present, and they were affixed by the owner. It would be reasonable to assume that an owner would want the land to improve by their presence. The tapestry were designed to enhance the Elizabeth character of the room. Comparing to our facts in the questions, where the advertisement for sale of the Victorian-style property is part and parcel with the exquisite painting from the Victorian era, we can say that Brenda actually intended the painting to affix to the wall, and it actually becomes a fixture and will be sold together with the property as a wall. Next, looking at the case of Harm against Bygrave, 1983, where items resting on their own weight were fixtures and chattels, and whether pre-contract discussion added any weight to this matter. Court held that the first test to be applied was the traditional test with regard to the degree of annexations to the property and the purpose of annexation. However, it was also held that while both of the elements in this test remains valid, the paramount test in the modern context related to the purpose of annexation, this was a necessary question of facts. The matter was decided firstly by stating that replies to the question prior to the contract did not provide a warranty on the part of the defendant that the items would form part of the land and parcels. However, secondly, this discussion did impact on the purpose of the annexations, which in this circumstance had the effect of causing the garden's ornamentals to be considered fixtures, and in turn result in them to passing with the property. It was the secondary effect of the statements meant that the defendant was stopped from denying that the items were included in the sales. Again, compared to our facts, the painting and sculptures was being placed in the Victorian-style property even though they are not affixed to the land, but due to the annexation of Brenda for the purpose of the decorations of the house, therefore increased the value of the land by fulfilling the Victorian-style property outlook. The selling price of the property will be higher since the sculptures and the painting are very valuable items, and therefore it can be regarded as a fixtures. The importance of the purpose of the painting and sculpture to the overall value of the property is to increase the property aesthetics and value by using the Victorian-style article to attract potential buyers. Here the buyer Abraham considered to buy the property because of the Victorian-style items which are sculptures and paintings, and these items plays an important part to Abraham's decisions, and he eventually thought the items would be included in the sale of the house. Meanwhile, the seller Brenda vaguely answered to Abraham that if he sealed the deal immediately. Here, Brenda, who answer is ambiguous and intended not to sell the items together with the property, but also want to perceive Abraham to buy the house. Challenge that might face by Abraham is that Brenda might argue that the painting and sculpture were not included in the sales and purchase agreement, and because Abraham did not seal the deal immediately, the issues relating to the sale and purchase agreement where Brenda vaguely answers Abraham if he sealed the deal immediately, they could discuss on the matter in the future, but Abraham did not agree to buy on the spot, and subsequently the inclusion of the painting and sculpture was not included in the agreement too. According to the express reference in the contract for sale, the ownership of the items is expressly referred to the contract, then the rules concerning the fixtures and fittings are displaced. So if the seller tells the purchaser that an item is going to be removed, even if it's firmly fixed to the property and under the test of annexation, would be held to be a fixtures. In the case of Taylor and Hammer, a case relating whether a fixtures prior to a contract should be restored to a property. Here, where the Asian paving slabs was part of the land and had actually inquired as if it's the remain which has been previously remained with the property, the purchaser here had relied on two clauses in the condition of sale which say the buyer accept the property in the physical state as it is and at the date of contract. The seller will transfer the property in the same condition as was the date of contract. Comparing to our scenario, even there is no mention in the sales and purchase agreement to include the items, but the fixture itself is meant to keep on the land and cannot be removed, and one will, which will make the sculpture and paintings belongs to the house, and Abraham will have possessions. In conclusion, Abraham is able to claim the painting and sculpture back from Brenda as the item were intended to become part of the land as to what the advertisement has mentioned, which is the Victorian style property. Thus, two items also fall under the purpose of increasing the value of the land. Thank you.